Good morning. You're all very welcome to the third annual. Okay, good morning all. We ready to go, Mark?
Yes.
Great. You're all very welcome to the third annual webinar of What's Market for Commercial Contracts. Presenting today will be myself, Wendy Hederman, from the Commercial Technology team, Mason & Karen, and my colleague, Mark Fry, also a partner in the Commercial and Technology team, as you can see us both there. Firstly, I just want to remind everybody that the webinar is being recorded. So I hope you're all okay with that. And secondly, slides will be available after the event. So don't worry about taking everything down. It's got a lot of detail on the slides. But here we go. Sorry, let's move along. Good. Hope everybody can see so Mark and myself now in stereo. And to briefly outline what we're going to talk about today. Well, firstly, what do we mean by what's market? For the past few years in the Commercial Contracts team in Mason & Karen, we've been tracking the main clauses in a wide range of contracts, whether it's a software license or a framework purchase agreement, distribution agreement, or an outsourcing. There are a handful of clauses found in almost all of these contract types that most often give rise to the trickiest negotiations. And certainly as in-house counsel, these are the provisions that your business colleagues will most often come to you on. Our clients often ask us, what's a reasonable position for us to take on our standard cap of liability? Or is it usual that a customer is asking for indemnities for a wide range of issues and breaches? So here in the Mason Hayes Contracts team, and that's a team of about 12 or 15 lawyers who regularly negotiate contracts, B2B contracts, week in, week out. We've been keeping track of what's been agreed in particular transactions, and we have a bank of clauses to deal with special cases. It has allowed us to sort of identify market practice and to spot trends in how these issues are being tackled in practice. And we've complemented our Mason Hayes tracker with a survey of in-house counsel. So those of you who've responded before will know this is our third annual What's Market survey. It allows us to establish with much more accuracy to get a fuller picture of what is market standard. And for this, our third annual survey, we had an even higher response rate. So we're able to identify shifts in market practice and also to see, some real consistency on some topics year to year. But before we go any further, I'd like to say a big thank you to all the counsel who responded. We really appreciate you taking the time to work through the queries. We have even bigger response than any previous year. So the topics we're going to look at are liability caps, types of cap, the size, the level of caps, and then special cases or carve-outs from those caps and super caps. We look at exclusions and liability, we turn to indemnities, and then a couple of other sort of topical issues, force majeure, particularly in the aftermath of COVID, governing law, good faith obligations, and also look at e-signatures. As we go through, we'll identify a few trends and then we'll sort of wrap that up at the end, and we will have time for questions. So please do share or put any questions to us by using the Q&A function on your screen. And we do our best to answer those at the end. We're allowing a little extra time this year, so I hope we'll get to plenty of your questions. Could I turn to you, Mark, and ask you, could you tell us a bit more about who responded to the survey?
Certainly, thanks, Wendy. You might just skip to the next slide. So firstly, I'd just like to reiterate Wendy's comments and thank everybody who took the time to participate in the survey. As Wendy mentioned, this is our third annual survey, and we have received by far the highest number of responses to date, which really helps us establish with a lot more accuracy what is market. You can see from the breakdown that the vast majority of respondents, unsurprisingly over 82%, were from organisations in the private sector. And of these, was approximately a half and half split between suppliers and customers, 56% suppliers and 44% of customers. Just for your ease of reference, when we go through the responses to the survey, we use color coding. So when you see we have bar charts that use blue, and that's where we're talking about supplier responses, and we use green for customer responses. In relation to the makeup of respondents, the biggest change to last year's survey is the increase in the proportion of respondents we've had from the financial services sector. That's now our highest number of respondents, at approximately 28%. In previous years, the main respondents would have come from the technology sector, which is still a significant proportion of responses, making up about 20% of those for this year. The makeup of the other organisations include a broad range of industry types across energy, built environment, healthcare, food and drink, manufacturing, professional services, retail, and education, and the proportion of those respondents is largely in line with what we would have received in feedback in previous years. Just move on to the next slide, please, Wendy. So the first issue we have inquired about was probably the most fundamental issue in any contract. That's the issue of liability, and often the matter that takes the most negotiation, as I'm sure many of you will be well aware of. The responses to our survey do show that the vast majority of respondents, both suppliers and customers, routinely include liability caps in contracts. Obviously, both suppliers and customers will come at liability positions from very different perspectives, and the levels of cap will vary depending on the contract, the subject matter, the value, and the bargaining position. Although we would say that we have seen that our customers use their bespoke contract as opposed to contracting on the basis of supplier terms. There generally is more scope for higher caps and liability. So we did ask, do you routinely include caps and liability? Data shows us that most suppliers and customers include caps, but mainly to protect their own interests. About 55% of suppliers and 46% of customers. When we're looking at the responses in survey to liability caps, generally we're talking about supplier caps and liability, though we have seen certainly an increased trend from customers looking to have separate liability caps that just apply to the customers. Traditionally, a customer's main responsibility under contracts would have mainly been just to pay the fees, but certainly in post-GDPR climate, customers are seeing that they themselves may be taking on increased exposure under contracts and looking to cap their liability in that context. But certainly from a customer's perspective, the suppliers are the key ones carrying out the services, and generally the expectation is that from customers at least is that suppliers should have higher caps and liability, and the position shouldn't be equated. So moving on to the next slide. So we asked which of the following approaches to caps do most commonly apply, and the approach from suppliers indicates that 26% of suppliers indicate they look to cap their liability at the total contract value, and that's down from previous years where about 36% of suppliers took that approach. Interestingly, we've seen an increase in the portion of suppliers at 42% of the responses who indicate that they typically approach liability on the basis of a fixed monetary amount. That's up from 26% in previous years. What's driving that trend is difficult to gauge. We are obviously living in inflationary times, and perhaps suppliers are looking for more certainty as to what their exposure is in a scenario where charges or value of contracts might be deemed to be increasing throughout the lifetime of it. It's difficult to tell from the data, and because we have also seen an increase in the number of suppliers indicating that they use a cap at a multiple of the annual fee. So that's increased from about 16% in previous years to about 32% in 2022. Moving on to the next slide. So the data we've got from customers, very much in line with what we've received over previous years, is that most customers will want caps and liability linked to a multiple of contract value or a fixed monetary amount. What we have seen, certainly in our own practice, is an increased trend of customers looking for the best of both worlds. So insisting on essentially a cap and liability linked to the higher of a fixed monetary amount or a multiple of the contract value. We're looking at the multiples that are commonly used. Next slide, please. So we asked, where you typically agree a cap as a multiple of the contract fee, which multiples do you typically use? Interestingly, the proportion of suppliers that indicate they typically cap their liability at 1 to 2 times the fees is up quite significantly to 69%. That's up from 52% of suppliers in previous years, and 27% of suppliers indicating that they would typically use caps at 3 to 4 times the levels of the fees. But the most significant shift that we've seen from previous years' data is a huge drop in the portion of suppliers indicating that they would typically agree liability at more than 5 times the contract fee. That's now only 3% of suppliers indicating that. In previous years, we would have had approximately 18% of suppliers indicating that. So again, perhaps indicative of a more cautious approach being followed by suppliers in the current climate. And the data from customers is largely aligned, I would say, from what we would have received in previous years, with about 56% indicating they typically agree 1 to 2 times fees. But again, this is when we're looking at this feedback, we're talking about general liability caps. For larger outsourcing contracts in particular, depending on the particular risks involved, it's quite common for parties to include and agree standalone liability caps to cover different categories of liability. And that's an area that we've asked about next in our survey that Wendy will speak to in a little bit more detail.
Thank you, Mark. Yes, so we understand from Mark that, just somewhere between 85 and 100% of contracts will routinely include caps. What I want to look at now is that there are many sort of exceptions or special cases to those caps, both as regards uncapped liabilities or tailored, specifically higher caps than the standard general contract cap. It is rare that you would have just one subclause of a contract on liability, with a range of caps being more common, certainly when you get to substantial B2B contracts. And move my slides along. Our question was, when do you apply a separate cap, either a lower, a higher, or uncapped liability for any of the following? And we show the data by 6 different types of contract obligation or breach. Again, we're looking just at supplier here because it's in blue, and we have the next slide in green for customers. This gives us a lot of data points. So to try and unpick this a little bit, taking the supplier responses first. So the first type of breach there on my left-hand side of the screen for GDPR breaches, next in confidentiality, then third-party IPR breaches. You can see at that first bucket on the left-hand side, breaches of data protection obligations, suppliers are having to give a higher cap about 53% of the time, or to agree to uncapped liability 41%. So that's indicative that nearly all the time there is a special liability arrangement for GDPR breaches. Similarly, in the next one, breach confidentiality, when you take the 44% giving a higher cap and 56% going uncapped, that's pretty significant. That's pretty much all the time being uncapped. And the next one, third-party Ipo infringements. This is the highest response we had in terms of uncapped liability at 71%. And when you add it to the middle column, the 23%, you've really got 94% of suppliers agreeing liability for IP infringements at more than the standard contractual cap. In fact, we can see that suppliers are most of the time being asked to go to give a higher cap than the standard for all 6 of these buckets. The one that's lower is on the general indemnities. The one that's lower is the 47% property damage, is the only one where more often a supplier will give a lower cap on liability. And there, when we're talking about defective products, remember, there's B2B contracts, so it's like different criteria will apply. If we're talking B2C, where you've got, strict liability under Liability Defective Products Act, where you're dealing with the consumer, you can't cap that liability in the same way. But, as regards trends against last year, well, turning back to that first bucket, the data protection breaches, even though that is the 53% to the 41% are pretty high. What is notable, I think, is that the bar for higher cap has actually increased, and the bar on uncapped liability has come down a little. Each of those is sort of changed by about 5 to 10%, which is consistent with what we are seeing. Certainly my experience is that last year and the year before, customers or suppliers, are feeling they're having to give uncapped liability, whereas now the conversation's shifted a little bit more to, yes, we'll have to give a higher cap, but less often is there an uncapped liability there. In the trends against last year, the confidentiality column slightly up on 2021. That was in sort of 85 to 90% range for those 2 columns, which are now up at like 97%. The third bucket, IP infringements, really quite consistent with last year. That uncapped liability stood at 70% last year, now it's 71%. I was just reassured when I see consistency. So at least there's we're getting the sort of the same messages, and that confirms our sort of what's market view. Other change as against last year, the final bucket, the indemnities generally has moved. Then in 2021, the last two columns together came up to about 80%. Not really sure the reason why those might be down. It could be that we have slightly different mix of respondents, or similarly in the 2P categories, that's going to be quite sort of specific as to whether you're dealing with an outsourcing, which will have 2P issues, or you're dealing with an IT software license, when 2P is not going to be as relevant. I'm going to move to the supplier side, and same question being answered by, customers. You can see that customers, similarly to the supplier side, they expect higher or uncapped liabilities for each of the first category, data protection, and confidentiality, similarly either higher cap or uncapped, and IPR, that's the first three buckets. As against 2021, this first category of GDPR breaches, like on the last slide, we are seeing that more customers are prepared to accept higher cap, i.e. 57%, rather than the uncapped. Customers accepting a lower than standard cap has almost disappeared under the GDPR heading. Last year that was 8%. I mean, I think, again, this illustrates that the conversation of GDPR caps has gone very much to, it's going to be a super cap. It's just a question of how high is that super cap going to be? And of course, 43% of customers looking for uncapped, still a significant amount, and it can mean that the negotiations can be tricky there. If we look to the confidentiality heading, as against 2021, is that liability will be uncapped is down slightly, and those accepting a higher cap is down from 43% to 32%, sorry, and the uncapped figure going up to 58%. Don't want to spend too much more time. The data, you have it all when you get the slides after the event. We did ask separately, on GDPR, and this comes up the question a slightly different way. So the numbers aren't exactly the same as the previous slides, but I think it shows the same trend. We asked, do you concede or ask for uncapped liability for GDPR breaches? And just a third of suppliers, at 32% of them, will accept uncapped liability either always or sometimes. Oops, sorry, back up. Always or sometimes. A smaller proportion, 21%, say no, we'll concede a higher cap. And the numbers saying they will not accept uncapped liability at all is at 47%. That's higher than in 2021, consistent with what I said on the last slides. On the right-hand side, the customer perspective, the proportion insisting always or sometimes an uncapped liability, 53%, is down from the 2021 figure of 65%. It is still a big number, more than half customers looking for it, but the uncapped is down and the higher cap has gone up a bit. One of the comments in the survey response was, they said, we'll always start by asking for uncapped liability, but almost always we have to agree to a cap, albeit a super cap. So what I'm seeing is that the disconnect that existed in 2021 between supplier and customer negotiating positions and GDPR has lessened a little bit, just coming slightly closer together. I think, Mark, did you hear anything there on, your experience on the uncapped liabilities and GDPR?
Yeah, certainly. I think while there would have been perhaps a trend pre-GDPR of having uncapped liability, and certainly in those contracts where personal data is heavily involved and there's an increased risk, we've seen parties more inclined to agree super caps, which is backed up very much by the data. We would those contracts where you do see uncapped liability would tend to be those where there's less risk with regards to the personal data, so the subject matter and suppliers are more inclined to agree it on that basis. But for contracts involving large processing of data, a super cap tends to be the way we've seen it go.
Yeah, I'd agree with that. Okay, so I think here, just to sum up a recap on the what's market. We've dealt with those first 2 points there. Well, certainly that there are a lot of instances, particularly the 6 buckets that we identified, customers and suppliers will approach those categories by having a higher cap, or in some instances uncapped. We said that the expectations between suppliers and customers has narrowed slightly, seeing more consistency on the 2 sides on some of those super caps and uncapped liability. On confidentiality and IPR, customer expectation and supplier gives are very close. So actually that's possibly why, though negotiating caps on those issues is not quite as contentious, because there's a real similarity in approach on those. We said that on GDPR, we are seeing a trend to higher cap instead of uncapped. Still a contentious matter, still a lot of customers looking for uncapped liability. And I think the learning for me from the practice, or what we're encountering in practical terms, is if customers or if it's suppliers can set out their stall, outline what they are offering or what they are expecting early on in the negotiation. So in one negotiation, I think in particular, the customer made it really clear from the outset, when it was before even sort of circulating contracts, that the transaction that they were opposing, it would need to have a supplier liability for data protection of not less than 20 million, or the thing just deal wouldn't progress. And while that was outside the supplier's comfort range, they knew that from the outset. And so the customer got what they were looking for. Whereas my experience otherwise, negotiating a 20 million cap on GDPR liabilities towards the end of the process was going to have been really, really tricky. Mark, do you want to chip in on that last issue?
So I think that our survey very much focused on the key areas where we see super caps and liability, or potentially uncapped liability. And the 2 other areas that we've mentioned there, we're starting to see a trend, anecdotally, from clients looking to carve out liability for willful default or gross negligence from the general aggregate liability caps. So they may have higher liability agreed for those heads of losses. And a lot of that is driven by the uncertainty from case law in relation to what's recoverable and what's not recoverable. So we would certainly say that if the parties are to agree a higher cap and liability for those heads of losses, be very clear on what they comprise. So when you talk about willful default, if you have a super cap for willful default, what does that mean? Does that mean it has to be an intention to cause harm, or is it essentially something analogous to a gross reckless disregard, which might be more equivalent to gross negligence? So certainly, if you are agreeing caps for those heads of losses, which we're starting to see, do try and document exactly what you mean that to comprise. And I think when we talk about exclusion clauses in general, which was the next area of our slides, and when you can just skip forward to the next slide, it really shows the importance of using very careful drafting when documenting what's covered by those and what's not. The most common exclusion clause we see in a contract is excluding liability for indirect or consequential loss. That's very much, data shows that's very much market practice. 95% of suppliers agreeing that, and 88% of customers agreeing it. One trend that we've started to see, and again, this is something certainly we see perhaps more larger contracts than smaller value contracts, is customers agreeing to document a list of some of the key types of direct losses that are agreed by them both to be foreseeable and recoverable under the contracts. That might include things such as the costs of reconstructing or reloading data, or costs to procure replacement services from an alternative service provider. But it just means, certainly from a customer's perspective, if those types of claims were to arise further down the line, they're less likely to be met with a claim from the supplier that those aren't foreseeable and should be excluded on the basis that they're indirect or consequential. There is quite a bit of uncertainty, or at least there was a perception in the past that loss of profit was always an indirect loss. And in reality, that's not the case. And it's very important to keep in mind that any financial losses that flow directly from a breach and that you would normally expect from the breach could be a direct loss. So each kind of loss can be direct or indirect. It really depends on circumstances and how foreseeable it was, in line with the Hadley and Baxendale criteria that many of you would be familiar with. So, a case of AG of Virgin Islands versus GWA shows that in certain circumstances, loss of profits can be recoverable. It can be direct. In that case, the losses that were arose from a design and build agreement were deemed to be within the contemplation of the parties at the time and were therefore recoverable. There's a lot of recent jurisprudence which perhaps took a little bit of a conflicting approach on what the consequences of calling out an exclusion of loss of profits would mean. One very substantial case which was actually only decided in the last couple of weeks was the case of Soteria Insurance Limited, formerly CIS versus IBM. So this was a really significant contract claim that CIS brought for £128 million in sterling against IBM for essentially the costs of a failed IT project. Implementation didn't go to plan, and those significant costs incurred as a result. At the High Court level, interestingly, the High Court, and many of you might be familiar with the rules under claims for damages, that at common law, you can't claim damages for both loss of profits and waste expenditure. It essentially has to be one or the other. And the High Court essentially applied that reasoning and looked at an exclusion of liability clause into the contract. And that clause essentially provided that the parties were prevented from recovering loss of profits, revenue, or savings in all cases, whether direct or indirect. And the High Court determined that essentially that meant that lost profits were also affected against waste expenditures. It equates the two types of claims. And the Court of Appeal, only in the last number of weeks, rejected the High Court's findings that waste expenditure should be excluded as being essentially equivalent to loss of profits. They looked at the actual words in the exclusion clause. There was a clause excluding indirect damages, including loss of profits, but it didn't specifically mention wasted expenditure in the clause. So the court reaffirmed the principle that while a claimant cannot claim for loss of profit and waste expenditure, this doesn't essentially mean that it can't exclude one or the other. And it looked at the actual wording and found it would be a justified jump of reasoning to determine that just because an exclusion clause called out all loss of profits, whether direct or indirect, didn't mean it also excluded a claim for waste expenditure. So it really shows the importance of parties at the negotiation stage trying to agree what types of losses are covered by an exclusion clause. If there is a broad clause that includes other heads of losses, such as loss of profits, we've seen pushback against that. We've seen parties only agreeing to exclude indirect loss of profits and leaving it open as to what types of losses might be recoverable. If waste expenditure is agreed to be excluded, the case clearly shows the need to document that and to agree what waste expenditure covers. So I think we turn to the next section on indemnities, Wendy.
Yeah, Mark, I think that Soteria case is really interesting, and that distinction between the exclusion clause calling out loss of profit, but not calling out wasted expenditure. I mean, it's sort of 120 million in the difference. Is that what you were saying?
They were at the High Court level. They were awarded actually 16 million pounds. Their claims were 128 millions. At the Court of Appeal, I think they got about 80 million pounds, but that was largely due to a separate cap and liability that then kicked in. So it shows a huge difference. I mean, they got about 70 million pounds extra through some very straightforward wording in an exclusion clause.
Yeah, very interesting. Okay, on indemnities, because indemnities can meet a huge resistance from some suppliers, and also can be something that customers are really looking for, particularly on particular issues. So we asked, again, the blue being the supplier, we asked which following indemnities in favour of the customer do you most commonly accept or expect? And the most commonly given or sought indemnities are the ones there with the highest bars, and data protection and third-party IPR. Interestingly, the third-party IPR, 86% of suppliers, very similar to 2021, where that figure was 85%. So 86% of suppliers and 74% of customers expecting IP indemnities in the contract. As to why the customer expectations on IP indemnities slightly lower than last year, might be that we've more responses from the FS sector this year rather than tech. But also back to the first bucket there, the data protection, 47% of suppliers giving an indemnity on data protection, 70% of customers expecting it. Those as compared to 2021, that 47% is up from 24 to 47%. The figures for personal injury caused by negligence at 47% and 44%, a little bit up on last year. And again, now we have the 2P indemnities up a little bit, still less common than the first three categories that I've discussed. Again, 2P won't be relevant to all of them. What's the takeaway from this slide? I suppose it's that there are notable, not necessarily huge gaps between the supplier and the customer positions. We have a fair bit of consistency on what indemnities are likely to be given or demanded in a B2B contract. Again, it's on DP that there's a bit more of a gap between supplier and customer, and that can make negotiations tricky. But having the consistency there on the personal injury indemnity, 47% to 44%, likely to be something that is kind of accepted practice in particular sectors or particular kinds of contracts. Just wanted to give a brief update on some of the law on indemnities. We did discuss indemnities in quite some detail last year for any of you who are on the call, and how indemnities are different to a breach of contract claim in terms of how the issue will be determined by the courts. And so an indemnity is very much a creature of contract, a clause as it's written. So the main case law on this is still the UK case of Wood v Capita Insurance. That's in terms of interpreting an indemnity clause, and that was where the UK Supreme Court interpreted indemnity clause in a share purchase agreement and said that you need to look at and ascertain the objective meaning of the language which the parties chose to express in their agreement, looking at the contract as a whole. And it was as to whether the purchaser, the share purchase agreement, could use the indemnity clause where itself had referred an issue to the FSA about mis-selling of contracts. The Wood case is still good authority in the UK. In fact, the case that Mark was talking about there a moment ago, Soteria Insurance, referred to the Wood case, and the principles of interpretation sort of consistent with and similar to what had been in Wood. In Ireland, in the Irish courts, the Wood case has been referred to, and if you like, sort of adopted or considered good law in a couple of cases I've listed there, all with citations, so you can find them. Just very briefly, the Hypertrust Leopardstown Inn v FBD Insurance PLC, that's more commonly known as the third FBD COVID disruption case. And it's the commercial court in January 2022 issued their judgment in that, holding that policyholders were entitled, that's policyholders being the pubs, including the LEP Inn, were entitled to be indemnified for lost profits due to COVID restrictions such as early closing of pubs, close at 10 p.m, whatever, and bar counter closures. The court looked closely at and carefully interpreted the specific wording of the indemnity provision to determine what the extent of the indemnity that they were entitled to from FBD. There's also the Point of Village case against Dunn Stores and Clarion Key Company Limited by Guarantee against Dublin City Council. In that third case, the court found that there was no obligation to indemnify under the clause in issue. It was in the context of a multi-unit development, the Multi-Unit Development Act of 2011. So essentially that brings you up to date on indemnities. And I suppose just to tie it back to something we were talking about earlier, again, watch when you're doing your indemnities, whether they are linked back into the liability caps. It is absolutely possible and feasible to cap indemnities. You just need clear wording to do that. And it'll be the wording of both the liability clause, the cap and liability clause and the indemnity clause, which will determine whether there is a cap on it or not. I think we'll move on to Mark, will you take force majeure?
Yeah, so force majeure, certainly an area of contracts I think pre-pandemic probably didn't get an awful lot of attention, but certainly our survey backs up the what we've seen on the ground, that parties are increasingly paying a lot more attention as to what comprises a force majeure event under their contracts. 65% of suppliers indicated they had revised or reconsidered their standard force majeure clauses in the last year, and approximately 42% of customers indicated likewise. And interestingly, most of the responses still indicated that COVID or the pandemic was the reason that the force majeure clauses have been updated. Only one respondent referenced Ukraine, so that doesn't appear to be as a significant concern as COVID has certainly been in the past. And it'll be interesting to see how things progress with next year's data if that changes. In relation to the force majeure clause itself, what we have seen certainly from a customer's perspective on the ground is that customers are increasingly expecting suppliers to have workarounds in place to perform in light of the pandemic. The pandemic has been ongoing for quite some time now, and customers have looked to revise the clause to provide that suppliers can't invoke the force majeure clause if it's attributable to a COVID-19 or other pandemic, apart from where a supplier is entitled to take measures to comply with applicable law, including, for example, laws that might restrict or prevent the provision of the services or the movement of the supplier's personnel. But otherwise, the expectation we've seen from customers is that we've had the pandemic for some time now, and suppliers should have in place appropriate pandemic contingency measures to allow them to continue to deliver the services irrespective of staff absences, unless there's particular legal measures there that impact. So the next question we'd asked was, have you had to seek or give relief or rely on a force majeure clause in the past 24 months? Slightly more objective question to what we had asked in previous years, where we just asked had you had to consider it. 29% of suppliers indicated they have had to seek or give relief and managed to get relief, which is consistent with the feedback we got from customers at 33%. On to the next slide, please, Mandy. We also inquired about what type of relief you did get or give. Interestingly, 45% of suppliers indicated they had obtained an extension of time. That was down quite significantly from last year's data, where approximately 63% of suppliers had indicated that. We've seen a jump in the number of suppliers indicating they'd obtained a temporary suspension at 45%. But interestingly, more and more customers are now reporting a price change, either an increase or a decrease. Although obviously, I think in light of recent times, they're more likely to get a rebate for slow or late performance. That was only 25% of customers reporting a price change last year. That's now at 45%, with the same level of suppliers. In practice, though, when you look at the type of relief that's given or granted, in reality, what we've seen in our practice is that most parties, if there is a force majeure event, would tend to cooperate, find a way to get the project done, ensure it's completed to the best of their endeavours on time, and at least, where there's a view to a long-term business relationship where it makes sense to continue that after the force majeure event has ended. A recent case, I think just on the next slide, a recent case that you might be familiar with that shows where relationships can break down was the case of European Professional Club Rugby versus RDA Television. And for any rugby fans out there, you'll be aware that the EPCR essentially own the rights to the two very large European rugby competitions. They had licensed the broadcast rights to RDA Television. And that case law essentially reiterates the principles that force majeure clauses are not implied as a matter of law. So there's no guarantee that the likes of a Ukraine-related event or COVID-19 will fall within the scope of the force majeure in all cases. It very much depends on the drafting of the particular clause. In that case, the RDA, even though evidence was given that they were really looking for a reason to get out of their contract pre-COVID, and it wasn't, I think, financially favourable to them, they were still able to rely on a force majeure under the contract that allowed them to terminate if a force majeure event continued for 60 days. The court looked at the clause and applied the general principles of construction. So they looked at the words, what's the actual meaning, what's the factual and commercial context, and what's the overall purpose of the provision of the contract, what are the facts known to be known at least or assumed by the parties, and what would be the meaning in light of commercial common sense and disregarding all subjective evidence of the party's intention. So force majeure, again, just reiterates, not a boilerplate clause, and we've seen an increased trend of parties focusing on what it covers, so they can agree very clearly in advance what's agreed to be included or excluded.
And Mark, I think that's very interesting. The one case you have there, it was that the court allowed them to terminate because the clause said if the force majeure continues for more than 60 days, then you got a right to termination. And in fact, that's been my experience, that clients, even if they are affected by external events, can be quite reluctant to trigger the force majeure trigger the force majeure clause, because then you're actually in the force majeure zone, and that can mean a termination of the contract if they can't, get away from that external circumstance. within the time. So I think on our previous slide, we saw that actually none of the respondents had indicated the contract termination was the outcome of the force majeure events. And so it is something that companies are wary of. I've had several negotiations between suppliers and clients where actually it's all done kind of in the shadow of the force majeure clause, but not actually formally invoking the force majeure provisions. So that's kind of interesting. Okay, we move on to our next topic, which is on governing law. Previously, we've been asking this in the context of Brexit, but as we really don't want to keep talking about Brexit, we are asking more generally on attitudes of Irish in-house counsel to contracts governed by the laws of England and Wales. And interestingly, was a very even split across the three options that we outlined for you. Almost a third, with slight variations. In that left-hand column, we have really that for 30%, 37% of suppliers and customers, contracting under English law is not an issue for them. In the middle, you've got 30% who will always insist on Irish law and jurisdiction. And actually, I think my experience, that 30% is very likely to be Irish public bodies or Irish regulated entities, or in particular, let's say hospitals or the statutory bodies, very reluctant to contract under the law of another jurisdiction. And I suppose they're not as accustomed to, they don't have operations in other countries where they would become familiar with English law. There in the right-hand column, you have 40%, 33% indicating that they'd accept English law and jurisdiction, but adapt the contract for specific Brexit-related or jurisdictional matters, such as data protection or data transfers. I'll move next slide, but Mark, you might want to take that.
Yeah, I might just jump in there. So I think probably one of the main reasons we've seen a decrease just in that last section that we asked about in our survey about whether, if you do accept English law, whether you look for specific changes. I think part of the reason we've seen a drop in the proportion of customers in particular, that's down, I think, was about 40% in previous years. In the number that are looking to make specific changes is because we now obviously have an adequacy decision for the UK, which allows for free transfer of information from Ireland to the UK. There was certainly a big concern, and it was only put in place, I think, in June of last year, that might be delayed. There was a period of grace, and there's a concern that parties might have to renegotiate their contracts to include specific provisions for SCCs, for example, to allow transfers of personal data to the UK. That's no longer as much a concern. So I think that's probably one of the key drivers behind that data, that we see a slightly less customers concerned about it.
Yeah. One area I wanted to mention, given the portion of council that are happy to contract under English law, like one thing you need to keep on your radar is this thing about the Lugano Convention. Since the UK left the EU, they're no longer subject to the recast Brussels regulation, which makes handling cross-border disputes more difficult. There was an expectation that the UK would be allowed to join the Lugano Convention in its own right. It's not absolutely identical to the recast Brussels regs, but it's very similar to a similar set of rules. But the UK applied to join that in April 2020. So far, the EU hasn't accepted their application, if you like. In fact, it's indicated that it's not inclined to allow them to join. Countries like France seem to be quite opposed to it. And maybe with the even more frosty relations that we have between the UK and the EU at the moment, not least over the Northern Ireland Protocol and compliance with international obligations, it's probably unlikely that the UK is going to join anytime soon. So it does mean that on enforcement of judgments and the issue of courts and jurisdictions, it's a matter of national law. So a matter of both Irish national law and UK national law as to how jurisdiction clauses and enforcement judgments will operate. It is giving rise for some clients to concerns about, well, how are we going to enforce this judgment if we were to get it under this contract? And I'm seeing some clients thinking again of arbitration, which avoids some of the jurisdiction issues, but then again, you need to enforce the arbitration award in another country. So it is quite possible that, you know, lower value claims may become uneconomic to pursue. That's sort of steer me given from some of my litigation colleagues. Not totally my area, but I just thought it would be worth flagging that for you. Okay, I think then we will move briefly on to, we're doing okay time-wise. We've two areas we wanted to discuss. So good faith, certainly there's been a little bit of movement on this, particularly in the UK and then a little bit in Ireland. So still worth keeping it on the radar. We asked you, do you include or accept obligations to act in good faith or to carry out your obligations in good faith? And so the survey results, the answer being yes, either generally we do, is at 39% in blue on the left-hand column and 40% in the right-hand graph. So they're both up by 10% on last year, you know, substantial proportion in its own right. If you then add in the yes buts, yes but only in specific instances, or yes but only if mutual, we're really up at about the 75% mark, which is reasonably high. It's only about 30% of in-house counsel who would never include that good faith obligation in the contract. I want to just move on briefly to the law. Again, we outlined this in more detail last year. So it's really to say that as a recap, there is no general implied duty of good faith in Irish law. It will be a matter of contract as to whether the party is included as an express obligation. And of course, there are those specific exceptions, such as under the commercial agents regulations, where there's an obligation to act in good faith on both the principal and the agent. And you get it as well in sort of consumer facing contracts in certain contexts. So the law in Ireland is as stated in the Flynn and Breccia case. And again, as you probably know, that does, the Supreme Court left open the door, allows for the possibility that a duty of good faith could be found in certain contractual relationships. What in the UK under the Bates and Post Office decision have been described as relational contracts. So as yet in Ireland, there has been no instance before the court where there has been such a relational contract, but it'd be not unlikely that an Irish court may find it. So we need to bear that in mind when both drafting and assessing what steps to take under a contract, particularly if there is a risk that it could be determined to be a relational contract. In the case that I put there, the Plus developments in the Lens Media, that was the Irish High Court, albeit at an interlocutory stage, looking at a express obligation to act in good faith, to negotiate in good faith, which was in an MOU. And that would not be an unusual circumstance where you do get an express obligation of good faith on the parties. And that dispute arose because the parties, albeit having applied themselves in good faith to negotiate the terms of an operating agreement, had failed to come to agreement on the operating agreement. And the question for the High Court was which of the other provisions of the MOU continue to apply. I've also mentioned a couple of cases there in the UK. They're really all sort of follow-ons from the Bates and Post Office case. For example, in the Pakistan International Airline Times Travel, the court dismissed a claim for economic duress, stressing that there wasn't an overarching duty of good faith in English law, in an English contract, unless it was a relational contract or an express term of the contract. So again, it's consistent with Bates. The Stobart, Capital and Eskin case, the court said it wasn't enough for the parties just asserting that it was a relational one. That wasn't in itself sufficient to establish a duty of good faith. The claim had to be particularised, and the claimant proved there was a relational contract as to what that would mean for good faith obligations. So the final notes there, as regards, yes, where it's come up for a couple of clients is where they do have a long-term contract, such as long-term outsourcing or a franchise arrangement, or long-term supply agreement, and determining what actions they take where the supplier is in breach and where they might have rights of termination, whether they should be considering well, this is one where the courts could find that it is relation contract, and in the way in which we go about terminating the contract, did we act in good faith? Is there a requirement to act in good faith? So just bear that in mind if you're looking at your long-term contracts that could come into that heading of relation contract. Okay, Mark, can I pass to you for the last topic?
Yeah, so this is just the final area of our survey, which we'll touch upon very briefly. And really, the data we received back shows what we've all seen in practice is the rise in the use of e-signatures. So if you just go on to the next slide, please, Wendy. We see that 61% of suppliers now always use electronic signatures. That's up slightly from about half last year. But the vast majority, either always or sometimes, of both customers and suppliers now frequently using e-signatures to execute contracts. Just move on to the next slide, Wendy, and one after that, please. And so in relation to the types of electronic signatures that are most commonly used, we've seen a slight shift in the number of suppliers that rely on handwritten signatures. It's down to about 40%, was previously in other years about 63%. And part of the reason that is really the drive that we see to using third-party signature platforms such as DocuSign. 100% of suppliers indicate they would accept those types of signatures, and about 85% of customers, which shows the increased trend in use of two-factor authentication platforms. Those platforms tend to use both email and perhaps PIN codes to give you a bit more security, and in many ways are perhaps more reliable than the traditional handwritten signature. In relation to the contracts itself, while under the E-Commerce Act, it's not strictly required because consent to use electronic signatures can be implied. As a matter of good contracting practice, we do see an increase in parties looking to include a clause in the contract just providing for use of these signatures. But again, for standard contracts, that's not needed. And for those interested in a little more guidance around these signatures, we've just included links on the following slide to various guidance that we have. When you can just move to the next slide. But obviously, for those of you involved in the property sector, you'd be aware that for certain types of agreements, particular deeds, e-signatures still can't be used. And I would just highlight that the Law Society is due to update its 2020 guidance on e-signatures. So we'll certainly keep a close watch on that, see what moves there may be on broader progression in relation to the property sector. So I think that, yeah.
Okay. Thank you, Mark, on that. So just we'll move to questions and answers, and just a reminder again, if people want to pop them in, we have a few questions in there, which we'll turn to now in a moment. Just to wrap up, the trends that we're seeing as against last year, I mean, I think the shift on some of the answers on caps for the super cap or uncapped liability for data protection is notable. There is a trend towards a higher defined cap instead of uncapped liability, albeit that the number of customers still expecting uncapped liability is significant and is something that suppliers are having to deal with. Mark, do you want to take the second point?
Yeah, so I think as we talked about earlier in relation to the GDPR, contracts and liability caps, our data shows a significant portion of customers applying super caps for data, and that very much depends on the nature of the types of contracts involved and whether they're heavily reliant on data or not. And certainly that's what we're seeing in practice, for example, in relation to hosting contracts or others that might merit higher caps in line with potential exposure under GDPR. We're also seeing trends, as we mentioned earlier, in relation to exclusion clauses. So increased focus from customers on what types of losses are deemed to be recoverable, listing those types of direct losses that are agreed between the parties as being foreseeable. On exclusion clauses, again, it's perhaps more from the supplier's interest. Suppliers want to call out very specifically what types of losses are excluded, taking into account some of the recent jurisprudence on issues such as waste expenditure, and certainly getting pushback from customers on excluding more broadly indirect and direct loss of profit.
And then I think also more generally in contracts, certainly from our practice, we're seeing, additional very specific clauses on compliance with particular sectoral regulation or sectoral laws, and whether that's, for medical devices or cosmetics, or more generally in the pharmaceuticals industry, or compliance issues such as I have there, regarding anti-corruption law or anti-bribery, and contracts in those for the sectors that I've called out, will have kind of peculiarities and specific issues that the parties need to address, but also then that's flowing into the liability clauses and the negotiation of caps, because for particular clients, if compliance with anti-corruption, and whether it's just anti-corruption law or it's with their codes and policies is important to them, well then they may be reluctant to allow a general contract cap to apply to breaches of anti-corruption laws or breaches of modern slavery laws. So that both sector specific but also regulation specific issues and how they're impacting exclusion of liability clauses is something that I'm seeing more of in the last year. I think also, on indemnities, definitely in practice, we're seeing a lot of negotiation around indemnities, the extent of indemnities, what's indemnified, what kinds of losses are indemnified, are there obligations to mitigate, how the caps or particular caps apply to indemnities, and the extent of issues that are subject to indemnities is definitely something that takes up quite a bit of time of our contracts team in terms of advising clients. And then that other bullet point I have there about, other jurisdictions influencing Irish contracts. We have been talking almost entirely about contracts governed by Irish law and the Irish law applying to liabilities, exclusions and indemnities. But we're definitely seeing that where our Irish customers are contracting with overseas parties, those overseas parties are going to bring with them their sort of expectations as regards uncapped liability and what's norm in their markets. And even as Mark was mentioning earlier on, gross negligence and willful default, it's something that has come in a lot to Irish contracts, even though it's not really a concept that's defined under Irish law. And actually the courts have shown us it's kind of quite a tricky thing or concept to interpret, but because it's very standard in continental jurisdictions, you're seeing it more and more being negotiated into Irish law contracts.
Yeah, and then just on the final point around the public sector, so what we're also seeing is that, and it's mainly in relation to issues of liability, that obviously public bodies being subject to very specific rules on procurement, we do tend to see them going to the market with a particular position on liability, and not being able to take a position where they could agree more favourable terms with the successful tender, and because that could potentially open them up to potential procurement challenge. So in relation to contracting approach and negotiation approach for liability, often we see public sector going out with their standard contracts or even with a bespoke contract with a very fixed position on liability and looking to hold tenderers to that without negotiating at a later stage, which could potentially open into a challenge. Yeah,
I agree on that. And particularly in the public sector, the contracts issued by the OGP, sort of standard form for services or goods and purchased by public bodies, the liability clauses in those templates that are issued to all public bodies to use has created a kind of their expectation in the market, and hasn't quite become a market standard, but it is the starting point for the public bodies that use those OGP contracts, and has had a bit of an influence even wider than that. Okay, I hope that's been useful in terms of outlining to you both the survey results and trends and what we're seeing in practice. We did extend this webinar last year. It was an hour long, and this year we made it an hour and 15 minutes. I think we've just about filled in the formal part of the webinar in the hour. So now that we have 12-15 minutes for questions, and thank you to those who have sent them in there. I'm going to start with one that was received from Tristan. Can caps on liability be extended to injury and or death, or do these sit outside caps on the basis of public policy considerations? I find that a really interesting question because there's a particular position in the UK, and a lot of Irish lawyers think that the same position applies in Ireland. I suppose because of commonality and of lawyers operating across the two jurisdictions, that has almost become the norm in Ireland. But in Ireland, the position is that when you're facing a consumer, you can't exclude your liability for death or personal injury arising from your actions. So in a B2C contract, no, you can't put a cap on it. And in fact, in the Consumer Rights Bill that's currently going through the Oireachtas to implement the Omnibus Directive, that such a clause, an exclusion liability for death or personal injury, will be a blacklist. It will always be unfair. When you're talking a B2B context, it is possible for one business to another business to cap the extent of liability of the first business for causing death or personal injury. In a way, it's sort of unusual, and indemnities would often be uncapped when it comes to death or personal injury, and that can tie back to insurance. But it's not illegal in Ireland for one business to cap its liability to the second contracting party, as in what's the extent that the first party is going to contribute if there is a claim for death or personal injury. Mark, do you want to add anything to that, or I'll move to a question for you?
Yeah, I'm happy to. I think, yeah, happy to
Okay.
move to any other questions we have there. So,
okay, so there's one here. What impact do you see the guidelines in the financial sector, sort of the EBA or CBI guidelines that they're talking about? What impact are they having on contract negotiations?
Okay, so I think that's certainly a very topical question from our, particularly for our financial services clients. So we have seen the guidelines have a significant impact. Obviously, that includes certain criteria that needs to be included in any contracts for important or critical outsourcings. I think in many cases, they're beneficial because the guidelines essentially provide regulatory backing to what a lot of regulated entities should be doing in normal course. It's good contracting practice, including those types of provisions to ensure oversight of the service provider. I think two particular areas that merit mention are the issues of sub-outsourcing and the requirements that need to be included on those in contracts. But I have an example. So some of the conditions are very specific on sub-outsourcing that need to be included, very much focused on the oversight of those parties, including allowing for direct audit rights, for example. Another area maybe worth mentioning is the issue of termination rights. Again, DBA guidelines on outsourcing, consistent with what's in the CBI cross-industry guidelines, include very specific rights that the parties need to include for termination and to capture that in contracts. We do see some challenges with the EBA guidelines. I think certainly a lot of contracts that clients would have had in place pre-EBA fall short of the requirements, and so we have seen have an impact on regulated entities having to go through the books and update their contracts and also to modify their template agreements to make sure that they're consistent going forward. Also, we still see some pushback from suppliers, particularly in certain areas that wouldn't necessarily be as used to such specific requirements as they might have with other clients, and that could be a particular area. Certainly with cloud providers who generally contract on their own terms and may be reluctant to agree to allow procuring rights of access in order to regulated entities. So yeah, that has a big significant impact and is very much an ongoing issue. Okay,
thank you. I'll turn to this one here. Hi, what kind of figures are you seeing when you refer to super caps? I suppose that's a refer question. We didn't give you specific figures other than starting the example that I gave towards the end, where 20 million was the level of the super cap for that particular client that was insistent that the super cap for data protection liability needs to be in the order of 20 million. Usually, I have to say, from my perspective, now it will of course depend on the sort of value of the contract that's been negotiated and the type of contract and even the size of the organizations involved. My experience, if we're talking about a super cap for things like GDPR liabilities or confidentiality or specific indemnities, in the region of 2 million, 3 million, 5 million. And I know that for my clients who are negotiating them, they have an eye to, or what level of insurance do they have for things like cybersecurity risks or hackings, or if it's a breach confidentiality claim, for actions or breaches by their employees. So in my experience, sort of talking 2 million, 5 million, 10 or 20 million will be the higher end of those super caps. What do you think, Mark?
Yeah, so just to add to that, and I think again it depends on what type of liability you're covering. So certain losses which the response to our survey shows, such as breaches of confidentiality or breaches of third-party IP infringement. Significant portion of those would normally be uncapped liability, particularly with IP. If you're expecting a software provider to stand over their IP, if you are to agree caps and liability for those heads of losses, because they're traditionally uncapped, we tend to see higher caps and liability in the potentially in the tens of millions, and depending on the types of contract. Data protection is the key one, because obviously there's it's potential exposure under GDPR, which depends on the value and turnover of the company. But I have seen caps for data protection for very high value outsourcings of 20 million, but generally would come in below that for most contracts. But it's really each party needs to look at the contract itself. What's the particular risk under that contract? Is something going wrong? And what is an appropriate level to cap it at in that context? And that's something which inevitably takes quite a good bit of negotiation.
Yeah. Okay, I agree. Okay, one here about, well, maybe I'll take one on indemnities, and then Mark, you have a look at the one on deeds and signatures. So I'll answer this one. As a supplier, is it market standard to give an indemnity for all breaches of contract? Actually, this is one of my sort of particular focus points, is that, a breach of contract claim is one thing, and an indemnity is a slightly different animal, and also is effectively for a somewhat different purpose. And while I'm not surprised at this question, because, suppliers are often asked to give an indemnity for all breaches of contract, so that every breach of contract just becomes an indemnity claim. To my mind, that's not great practice, and it's sort of not taking account of the fact that they are two different types of claim. I would say, and this is the position I take on behalf of suppliers, is that an indemnity is appropriate for particular trigger events, particular types of loss, kind of particular events arising. And yes, fair enough to use it for particular kinds of contract breach. For example, indemnifying for a breach of corruption laws and everything that flows from that. And they could be direct and indirect. And then it's, you're under indemnity principles. Or indemnity, for example, breach of 2P provisions. But my view, and I think generally here in the contracts team, Mason Hayes, is that an indemnity for all breaches of contract is not really the way to go. In fact, I do over the last year have checked, if you look at the PLC notes on drafting and negotiating indemnity clauses, they would say that that's the position too in the UK, that it's not common to give an indemnity generally for contract breaches, although I think they pick out some jurisdictions in the continent where it is more common. And also I think there's a world in contracting that came out in 2020 with a recommendation that indemnities should be limited to specific sort of defined events. So that'd be my approach. I know, Mark, do you want to chip in on that, or do you want to take the question on deeds?
Yeah, no, I think we've got quite a few questions to get through, so maybe I'll plan to the next one. So I think there's a question there about, have you seen any move by companies to accept deeds? I think in practice we haven't, and a lot of that is due to the restrictions under, for e-signatures currently, certainly from the property angle, that parties don't expect to be able to use them to execute deeds. Well, there will inevitably be a move towards that further down the line, but it's not something that we would have seen in practice. And I think certainly the reluctance isn't just driven by by the restrictions that are in relation to e-signatures. There's also kind of corporate governance issues as well in relation to what's in the company's internal governance documents that allows them to execute certain documents by deeds. So they have the facility and the freedom to do that electronically or not, and there may be very specific requirements as to how that's done in practice. So I think because of those issues, we haven't actually seen a trend towards companies doing that to the extent that we maybe would have expected with other types of arrangements.
Yeah, and it's not our recognition, but it certainly requires a lot of more technical requirements that you're fulfilling, the requirements for witnessing and the seal, etc. Okay, Mark, I think I'll throw this one to you too. This question just come in from Louise, maybe sector specific, but are you seeing any trends towards ESG undertakings being more prevalent?
Okay, so towards environmental, social type.
Yes, ESG, environment,
Yeah, so we have certainly quite a broad variety of ESG provisions, but I think more generally, leaving aside specific contractual clauses, a lot of parties when they're contracting tend to take that into account in the commercials. So, for example, if there's a specific drive towards using renewable energy, they might include certain provisions to try and facilitate that under the service delivery. So, yeah, we do see trends in relation to ESG type clauses being included in provisions, where anti-slavery, AML type provisions could potentially come into that bracket. But more broadly, we see it reflected in the commercials and how kind of parties are engaging with each other with an increased focus on ESG type issues as part of the overall service delivery.
Yeah, okay. Well, look, I think as we're just at time and don't want to impinge on the audience's day any further, I think I will just read the last questions that has come in and then wrap up. So the last one was, thanks, Wendy and Mark, for the presentation. Very useful, interesting to see the trends in commercial contracts at the moment. So that's an easy one for me to call out. I hope that has been useful for you. I want to thank all of you, the audience, not only for joining us today, but also for responding to our survey. As I said, the slides will be sent to everybody who attended. I want to also thank Mark for doing this seminar with me. I want to thank the Mason Hayes events team who helped the logistics and the arrangements to have this event presented here for you. I think there are over 200 online at certain times, so not an easy task. And just before I wrap, I'd like to say that you will get a survey pop up on screen, and we really appreciate your feedback, and also like to hear from you on future topics for webinars, or if you like future topics for this specific webinar, we'd be interested to hear that as well. So without further ado, that's it from Mark and myself. Thank you all very much for attending, and we look forward to getting your feedback.